I'm John Harrison, and I've been practicing family law in California for 15 years. In that time, I've seen just about every flavor of human drama imaginable unfold within the walls of a courtroom, but few cases have stuck with me quite like the one where a 17-year-old boy sued his own parents to gain his independence. The phone call that preceded his visit was from a social worker, sounding grim, hinting at something beyond the usual teenage rebellion. She used words like exploitation and coercion. I braced myself, but nothing could have truly prepared me for the quiet desperation in Michael Hayes's eyes when he first walked into my office. He looked younger than his age, slender and a little hunched, carrying a backpack that seemed too heavy for him. He introduced himself in a voice that trembled slightly, explaining in clipped, careful sentences that he wanted to be emancipated from his parents. My initial thought, as it often is with young clients wanting emancipation, was that this was a headstrong kid upset about a curfew or a car. But then he laid out the first shocking detail, and my professional skepticism evaporated. Michael wasn't just wanting to escape parental rules. He was trying to reclaim his very identity and future from parents who, he alleged, had hijacked his burgeoning career and were systematically siphoning off every dollar he earned. What was truly at stake wasn't just his freedom, but potentially hundreds of thousands of dollars he'd earned, his entire professional future, and his emotional well-being. This wasn't about a teenager being difficult. This was about a young man fighting for his right to exist as an individual. Here's what you need to understand about emancipation in California. It's not a decision taken lightly by the courts, and for good reason. Under California Family Code, Paragraph 7120, a minor can petition the court for a declaration of emancipation if they are 14 years of age or older, are living separate and apart from their parents with their parents' consent or acquiescence, or by court order, and are managing their own financial affairs. Crucially, they must demonstrate that they are mature enough and capable of managing their own affairs, including the ability to support themselves without parental guidance or control. The law is designed to give a path to independence for truly self-sufficient minors, typically those who are married, in the armed forces, or, like Michael, financially independent. However, courts are inherently protective of minors, and they assume parents act in their child's best interest. To overcome that presumption, and to prove a minor is ready for full adult responsibilities, requires a mountain of evidence. Most emancipation petitions fail because the minor can't prove all the statutory requirements, particularly living apart and financial self-sufficiency. This case was different. Michael wasn't just saying he was financially self-sufficient, he was financially self-sufficient, and his parents were the ones actively preventing him from exercising that independence. That nuance made this case particularly compelling and, frankly, enraging. Michael Hayes was just 17 years old, a senior at Palisades Charter High School when he walked into my office. But don't let the age fool you. He had the drive and entrepreneurial spirit of someone twice his age. For the past 2 years, he had been building a remarkably successful online presence as a musician and content creator. He composed original electronic music, produced engaging videos showcasing his creative process, and cultivated a loyal following on platforms like YouTube and Patreon. His earnings weren't pocket money. They were substantial, easily surpassing what many adults make, flowing into bank accounts ostensibly set up for him. When he first started making serious money at 15, his parents, Richard and Susan Hayes, were thrilled. They'd helped him set up a business account but insisted it be a joint account, ostensibly for tax purposes, and to teach him financial responsibility. Michael, trusting his parents, agreed. The initial months were fine, with his parents helping him manage his taxes and investing a small portion. But then things started to shift. He described a gradual, insidious takeover. First, they started limiting his access to his own debit card and online banking, claiming he was spending too much, despite his purchases being legitimate business expenses for equipment. Then they began making large withdrawals from his account for what they called family expenses, but which Michael recognized as upgrades to their home, a new car for his mother, and lavish vacations for his parents. When Michael protested, asking for access to his own funds to buy new audio equipment crucial for his work, they'd refuse, telling him he was too young to manage that kind of money, and that they knew what was best. His emotional state was a raw blend of anger, betrayal, and profound sadness. He loved his parents, but he felt utterly suffocated and exploited. He had tried to talk to them countless times, but his pleas were met with gaslighting, threats to shut down his accounts, and even emotional blackmail, claiming he was tearing the family apart. His grades, normally impeccable, had started to slip, and he was becoming withdrawn. He was clearly a bright, empathetic young man, but the burden of this conflict was crushing him. I took his case because I saw not a rebellious teenager, but a creative soul being systematically drained of his potential by the very people who should have been nurturing it. The investigation phase for Michael's emancipation petition was unlike many family law cases, bordering on a financial fraud investigation. My first step was always to listen, and Michael provided a detailed, if emotionally charged, narrative. His story had specific dates, amounts, and locations, which gave me a solid foundation. We needed to prove two things: Michael's undeniable ability to support himself financially and manage his own affairs, and his parents' active obstruction and exploitation. First, I helped Michael draft a formal letter to his parents, requesting full access to all his business and personal accounts along with a detailed accounting of all expenditures. As expected, they refused, citing his age and their legal guardianship. This refusal was a crucial piece of evidence in itself, highlighting their obstruction. Next, I issued subpoenas for bank records from all accounts Michael had identified, including those he knew his parents were accessing. This was a critical step. While Michael had screenshots of some transactions, we needed the official, unredacted statements. I also had him gather every piece of digital communication he had with his parents related to his finances, his work, and his desire for independence. Text messages, emails, and even DMs from social media. These were incredibly revealing, full of his parents' controlling directives and thinly veiled threats. I knew their counsel, Miss Eleanor Vance, a formidable attorney known for her aggressive tactics and often questionable ethical boundaries, would try to paint Michael as an ungrateful, rebellious child. My strategy was to counter that narrative with irrefutable financial proof and Michael's mature, consistent testimony. I brought in a forensic accountant, Sarah Chen, a meticulous professional I'd worked with before. Her job was to trace the money. We cross-referenced Michael's income statements from YouTube, Patreon, and his music distributors with the bank accounts his parents controlled. This wasn't easy. The parents had multiple accounts, some of which were personal, others business-related. Sarah meticulously followed the money trail, identifying deposits and withdrawals. What she found was damning. There were consistent, large transfers from Michael's business account, originally meant for his earnings, directly into his parents' personal checking and savings accounts. These weren't reimbursements for expenses, they were substantial sums, often 5 figures, happening almost monthly. We compared these transfers to their declared income and expenditures. We also found receipts from luxury goods stores, high-end restaurants, and airline tickets, all paid for from these siphoned funds. Ms. Vance, as predicted, argued strenuously against our requests for full disclosure, claiming attorney-client privilege and privacy, but Judge Reynolds was not swayed, understanding the core issue of a minor's financial well-being. The investigation was slow, spanning nearly 4 months. Each subpoena and subsequent discovery motion met with resistance, but Sarah kept digging. We also obtained Michael's school records, which showed a consistent record of high academic achievement and responsibility, further bolstering his case for maturity. The breakthrough moment arrived on a Tuesday afternoon. Sarah Chen called me, her voice buzzing with a controlled excitement that I immediately recognized. "John, I've got it," she said. "The smoking gun." She had just finished analyzing a series of bank statements from an offshore account, which the parents had tried to conceal by claiming it was a legacy account belonging to Richard's estranged uncle. Through an international banking inquiry and a carefully worded subpoena that finally cleared all hurdles, Sarah discovered that this account, too, was receiving direct transfers from Michael's business earnings. My heart raced when I saw the detailed spreadsheet she sent over, highlighting dozens of transactions totaling over $300,000, all funneled into this offshore account, completely beyond Michael's knowledge or access. This wasn't just managing money, this was hiding it. Coupled with this, Michael located an email from his father, sent to him just weeks before he came to my office. In the email, Richard Hayes explicitly stated, "If you continue to be uncooperative, we will have no choice but to shut down your accounts and revoke your access to YouTube. You are a minor, and we control your future." The legal significance of this was monumental. It utterly demolished any pretense that the parents were acting in Michael's best interest or merely managing his funds for his future. This was coercion, pure and simple, and outright theft. It was evidence of systematic exploitation and a clear attempt to deny Michael his right to manage his own substantial earnings. When I called Michael to tell him, there was a long silence on the other end of the line. Then I heard a choked sob, followed by a profound sigh of relief. "They can't deny it now, can they?" he whispered. "No, Michael," I told him, "they can't." The courtroom on the day of the hearing was surprisingly quiet, almost reverent for a family law matter. Superior Court of California, Los Angeles County, Dept. 12. Judge Elaine Reynolds presiding. She was known for her no-nonsense approach and sharp intellect, with little patience for dramatics. The air was thick with tension, palpable enough to cut with a knife. Michael sat beside me, dressed in a simple, well-fitting suit, looking composed but noticeably pale. Across the aisle, Richard and Susan Hayes sat stiffly next to Ms. Eleanor Vance, who wore a confident, almost smirking expression. My first witness was Sarah Chen, our forensic accountant. She walked the judge methodically through the labyrinthine financial statements, her voice clear and dispassionate, presenting the detailed spreadsheets on the large monitor brought in for the occasion. She highlighted the deposits from Michael's revenue streams and then, in stark red, the transfers directly into the parents' accounts, including the newly revealed offshore one. "Based on my analysis," she concluded, "over $300,000 of Michael Hayes' earnings were transferred directly into accounts controlled solely by Richard and Susan Hayes, with no discernible benefit to Michael himself, nor any documented reimbursement or explanation provided." Ms. Vance's cross-examination was predictably aggressive, trying to discredit Sarah's expertise and suggest the money was for Michael's upkeep or future college fund. But Sarah held firm, calmly explaining that such large, undocumented transfers were inconsistent with legitimate financial management for a minor. Then came Michael's turn. He testified with incredible poise, explaining his creative process, his online business model, and the meticulous care he took with his work. He detailed how he managed his online presence, his budget for equipment, and his plans for future investments. When he spoke about the gradual erosion of trust and the feeling of helplessness as his parents took over his finances, his voice, though still quiet, resonated with a deep maturity. "I just wanted access to the money I earned," he stated, looking directly at Judge Reynolds, "so I could keep building my future. They told me I was too young, but they were using it for themselves." Ms. Vance's cross-examination tried to paint him as a spoiled, ungrateful child, pressing him on instances of teenage rebellion, minor arguments over chores, and missed curfews. "Isn't it true, Michael," she sneered, "that you just don't like being told what to do by your parents?" "I don't like being stolen from, Miss Vance," Michael replied, his voice firm, "and I don't like being threatened." A ripple went through the courtroom. Finally, it was Richard Hayes' turn to testify. He presented himself as a concerned father, managing his son's fortune responsibly. He claimed the transfers were for family expenses, or being held in trust for Michael's college. I let him speak for a while, letting him dig his own hole. Then I began my cross-examination. "Mr. Hayes," I began, holding up a printout of a bank statement, "can you explain this transfer of $25,000 from Michael's business account into your personal account on March 14th of last year?" He mumbled about a new roof. "And was that new roof for Michael's bedroom, Mr. Hayes, or for your primary residence, which you own jointly with Mrs. Hayes?" He stammered, avoiding my gaze. I then showed him receipts for a luxury cruise, designer clothing, and a high-end watch. "Were these also for Michael's future, Mr. Hayes?" He went beet red. Then I displayed the damning email on the large screen, the one threatening to shut down Michael's accounts. The words, "Shut down your accounts and revoke your access to YouTube. You are a minor and we control your future," loomed large for everyone to see. "Mr. Hayes, is this your email address?" Did you send this email to your son? He swallowed hard. Yes, but it was just a threat to get him to cooperate. The admission hung in the air like a guillotine. Then I presented the bank statements showing the transfers to the offshore account. Mr. Hayes, can you explain why over $300,000 of your son's earnings were transferred into this account, an account that Michael had no access to, and which you failed to disclose until compelled by court order? His face drained of all color. He looked at Miss Vance, who had her head in her hands. The courtroom went silent. Judge Reynolds stared at him, her expression a mixture of disappointment and stern disapproval. He had no answer. The judge's ruling came swiftly, just a week after the hearing. Judge Reynolds did not mince words. She found that Michael Hayes had not only met, but far exceeded, the legal requirements for emancipation under California Family Code, Paragraph 7120, et seq. She specifically cited his demonstrated financial independence, his mature and responsible management of his own affairs, and the clear evidence of his parents' exploitation and obstruction. The judge stated that the parents' actions amounted to a breach of their fiduciary duty and a gross misuse of their parental authority. The specific outcome was a complete victory for Michael. He was declared legally emancipated, effective immediately, meaning he was granted all the rights and responsibilities of an adult. His parents no longer had any legal control over him or his finances, nor were they financially responsible for him. Furthermore, Judge Reynolds ordered Richard and Susan Hayes to repay Michael the full $300,000, plus accrued interest, that they had siphoned into the offshore account and their personal funds within 60 days. There were no criminal charges filed at that time, but the judgment itself was a severe consequence, not just financially but to their reputation. Michael's reaction was profound. He simply leaned his head back against the chair, tears streaming down his face, a silent, overwhelming release of months, if not years, of stress and anxiety. The weight was finally lifted. Within weeks, Michael had opened new bank accounts in his own name, moved into a small apartment near his school, and was actively managing his finances, his career, and his life with a newfound confidence. Here's what I learned from this case. Beyond the statutes and the precedents, the bonds of family, while often a source of strength and comfort, can also become instruments of profound control and exploitation. This case was a stark reminder that even in the most intimate relationships, unchecked power can lead to desperate and damaging actions. The broader legal lesson for viewers is clear. Emancipation isn't just for rebellious teens. It's a vital legal avenue for minors who are genuinely self-sufficient but trapped in exploitative or dangerous home environments. Warning signs people should watch for, whether they are a minor or an adult trying to help a minor, include parents or guardians controlling all access to money, threatening to shut down income streams, unexplained expenditures from a minor's earnings, and emotional blackmail when independence is sought. My practical advice is simple. If you're a minor earning significant income, always seek legal counsel early to understand your rights regarding your earnings and financial independence. Document everything, every text, every email, every bank statement. For parents, this case should serve as a cautionary tale about respecting a child's autonomy and financial independence, even when they are minors. The legal system, especially in California, is designed to protect minors, and when parents act against their child's best interest, the courts will intervene. It's a sobering insight into human nature, revealing how fear, greed, and a misguided sense of entitlement can warp even parental love into something truly destructive. It's been over a year since Michael Hayes was emancipated. He's thriving. His music career has exploded. He's attending college part-time, and he lives entirely on his own terms. He sends me an update every few months, always with a genuine tone of gratitude. He's still building, still creating, but now with a secure foundation and the knowledge that his future is truly his own. Cases like Michael's are why I do this job. They remind me that the law isn't just about dusty books and complicated procedures, it's about giving a voice to the vulnerable, empowering the disempowered, and restoring justice when it feels like everything has been stripped away. If you have questions about emancipation or any family law matter, drop them in the comments below. I've got plenty more stories to tell, and I'll be back soon with another one.